against Griffiths.
Good morning, Mr. Stevens.
Good morning, my lords. My lords, yesterday I was asked about the use of the word accuracy in Brown and Dunn, with which I dealt. But I've remembered overnight that my Lord Hodge also asked me about the use of the word inaccurate in paragraph 53 of Chen,
Yes.
which I omitted to deal with yesterday. So can I just deal with that briefly first? The answer as to what the court was concerned with lies in paragraph 54 in my respectful submission, because one can see from that what they must...
Page 330, isn't it?
330, I do apologise. One can see from that the following. I start 6 lines up in the middle of the line. Paragraph 54, my lord.
Yes, got it. Thank you.
So 6 lines up in the middle of the paragraph, it appears to the board that an appellate court's decision whether to uphold a trial judge's decision to reject a witness's evidence on grounds which were not put to the witness must depend on the facts of the particular case. Ultimately, it must turn on the question whether the trial, viewed overall, was fair, bearing in mind that the relevant issue was decided on the basis that a witness was disbelieved on grounds which were not put to him. So in that case, at least, it was in that context that the board was speaking, namely in terms of evidence being challenged for untruthfulness and being disbelieved.
Yes, undoubtedly the Chen case was about a challenge of incredibility, but the use of the word inaccurate might suggest that the scope is wider. But as you say, what the board is saying there is that it depends on whether the trial overall was fair.
Well, that, and then expanding by saying what it ultimately must turn on. And in both cases, the board is speaking generally not to the facts of Ing and Chen, or Chen and Ing, forgive me, in my respectful submission.
Yes, thank you.
It would also be convenient at this point, before I return to where I was, because it's a convenient prelude to what I'm going to say next, just to return to my Lord Stevens' question. If I may. My Lord Stevens, I hope I'm accurate in the way in which I summarise the question, asked me whether Brown and Dunn might also apply where, for example, accuracy of memory was an issue.
Well, I think it was not only me, but a number of other justices.
Well, I think it was your question in the first instance, my lord, but certainly others also asked me the question. At any rate, can I just respond further? As follows. The question whether the rule is engaged, in my respectful submission, is always going to be a matter for the trial judge because it will be fact-sensitive and depend, as we've seen in any number of the authorities, upon the issue of fairness in the trial, but also to the witness. It will therefore depend on, among other things, the importance of the issue and other evidence in the case. So it's always going to be fact-sensitive. Now, having said that, I accept, as I think I did yesterday, that depending on the facts, it may be necessary to challenge a witness's recollection in cross-examination, but equally it may not. And in a moment, I'll take you to a case that may be an interesting working example of precisely the question that more than one of your lordships raised with me about this. But can I just make a final and more fundamental point? I know your lordships have it, but fundamentally, we of course submit that there's no question of the rule having been engaged in this case because the court was not invited to reject the evidence of Professor Pennington merely to find the case not proved. Now, my lord, the case that I'll just take you to, because if for no other reason than it provides a working example in the context of recollection of a witness, is MBR Acres, which is at 945. It's a decision of Mr. Justice Nicklin, it's a decision after the decision of the Court of Appeal in the present case, and we'll see reference to this case. It was a contempt application against a solicitor, and an important issue was whether the solicitor had notice of an injunction. Can I ask you to turn to paragraph 87 at page 974? Where the learned judge said, before leaving this issue, I need to deal with a submission that Miss Bolton made to me to the effect that I was bound to accept P.C. Shale's evidence and to reject the evidence of Miss McGivern. This was so because she argued Mr. Underwood QC had not properly challenged the officer to the effect that he had not shown the injunction to Miss McGivern on his laptop. And then, my lords, you'll see reference to some familiar cases. At the top of the next page, at 88, Mr. Justice Nicklin said, I reject the proposition of law advanced by Miss Bolton. I'm satisfied that the rule is accurately stated in Phipson. And then there's citation of the 12th edition of Phipson. At paragraph 89, we see the reference to this case in the Court of Appeal. I have also considered the Court of Appeal's decision in Griffiths, which is referred to in this passage from Phipson. As my learned friend pointed out yesterday, it's referred to in a footnote to the heading in Phipson. A point that I put to Miss Bolton in argument was that this rule was principally concerned with two things: fairness to a witness, i.e. not inviting a tribunal of fact to disbelieve his or her evidence if not challenged, and fairness of the proceedings. It was not a rule that bound the tribunal of fact.
What's that mean?
Well, that it's a flexible rule and not one that the court is slavishly bound to follow in prescribed circumstances.
It is one that in certain circumstances it may be required to follow.
Indeed. So I think it's entirely at one with the authorities that you've been shown in that respect about the flexible nature of the rule and the touchstone of fairness.
Could it be, Mr. Stevens, that where the rule applies, if there's a failure to cross-examine, then you're stuck with it, but that the implications of that will depend on the context of the case, what the other evidence in the case was?
Well, my lord, that might be a different way of coming to the same conclusion. In my respectful submission, it's not engaged. In other words, you don't have to put the matter by way of challenge if it will not be unfair to do so, or not to do so, I should say. But I think it comes very much to the same thing, ultimately. My lord, can I just read on? At paragraph 90, in an adversarial system, an obligation falls on the party to put questions on any significant factual issue upon which that party intended to rely to any witness of his opponent who could reasonably be expected to have evidence to give on the point. So that's about putting a factual case. A failure to observe these principles does not immediately put the tribunal of fact into a straitjacket, dictating what evidence must be accepted and what must be rejected. It may be that basic fairness would compel a judge to refuse to condemn a witness as a liar if she or he had not been given an opportunity to address the challenge to his or her honesty, but that example is stark. In most other cases, the failure to put a relevant point to a witness is likely simply to be a factor in the court's overall assessment of the evidence. Now, there's then citation from the judgment of Lord Justice Nugee, and it's paragraph 81 of his judgment, in this case at 136, and I think it is entirely accurately set out, and I took you to it at the very beginning of my submissions when I was addressing the essential functions of the court. Just turning to the next page, paragraph 91, that is the case here. Ultimately, my duty as the judge is to assess the evidence presented on the contempt application. In this case, the principal issue in dispute is whether Miss McGivern knew of the terms of the injunction as a result of being permitted to review it on P.C. Shale's laptop. That was the evidence that he'd shown it to her on his laptop. I accept Miss McGivern's evidence on this. I have explained why I've not found PC Shale's evidence to be reliable. Now, the explanation, just pausing there, if you turn back to page 973, comes in paragraph 83, and there are various things which undermine the reliability in the judge's assessment of PC Shales. I won't read paragraph 83, but it's at 973. And then going back to 91 and reading on, I'm not bound to reject Miss McGivern's evidence as a result of the cross-examination of PC Shales. It was not Miss McGivern's case in cross-examination that PC Shales was lying. Her case was that his evidence was not reliable. It may be that strict adherence with the rule may have suggested that Mr. Underwood should have put one further question in cross-examination to the effect that PC Shales was mistaken in his recollection, but that is as far as the point goes. Miss Bolton did not in fact seek permission to recall PC Shales to have Mr. Underwood put that question. Perhaps that was a recognition of the futility of seeking to do so. So, my lords, I don't cite this as authority for any particular proposition, but I simply show it to you as a working example in the context of the question that was put to me about recollection and how the rule may or may not be engaged or infringed, depending on which way one looks at it, and it being fact-sensitive. My lords, can I now...
I remember when I was practicing in Scotland, and the issue of failure to put a matter on cross-examination was raised in closing submissions. The judge would say to me, well, that's a matter not of exclusion, but of comment. In certain cases, you were entitled to, the judge was entitled to take into account the fact that a witness had not been given the opportunity to address an assertion that was being made. So, as you say, it can be it is fact sensitive.
Indeed. I mean, there's one example in a criminal case in the bundle, I forget which one it is, but certainly in criminal cases, one can get to the position where a failure by a defendant to put something to a prosecution witness and then to lead evidence of what they want the jury to accept can be the subject of comment by the judge in his charge to the jury to the effect that you may take that into account when considering the credibility of the defendant. So there are any number of ways in which this can play out in practice. But, my lords, I hope, although not a proposition of law I'm trying to get from that case, I hope it's a helpful working example.
I mean, it looks as if PC Shales was quite vigorously cross-examined in that case. The only question is whether the cross-examination went far enough.
Well, went to the point in issue, my lord. So, yes. Yes. But, I mean, that is a critical...
It was obvious that whether she had seen the terms of the injunction on his laptop was a central issue about which PC Shales was cross-examined.
Yes.
One of those cases where he simply wasn't cross-examined at all.
No, I hope that was clear from the passages I read, and I certainly wasn't seeking to suggest otherwise. No.
In one sense, it's an outworking of the concept of fairness, because the judge goes through whether it was unfair not to have left out that single question.
I accept that, my lord, and I hope I fairly accepted in the second submission I made this morning in response to the question that I accept that depending on the facts, it may be necessary to challenge a witness in relation to their recollection, because fairness might require that, and it might require a specific challenge on a point, even if there's been cross-examination on other points. It all depends. But of course, none of this is what, in my respectful submission, and I risk repeating myself, and I'll doubtless do it again in the next hour or so, none of this is relevant in the present case in my submission, because there was no engagement with the professor. There was merely an invitation to the court to find the case not proved. But I'll be coming back to that. My lord, as I've just submitted, the present case, where I got to yesterday, my lords, was I think Edward's Life Sciences, and I'd taken you back to paragraph 65, and I'd read what Lord Justice Floyd stated. Now, as to experts, clearly impugning an expert on the basis that he or she is dishonest, or in a way that amounts to an attack on professional reliability, for example, a challenge to integrity or professional competence in the way I intended that phrase, as I explained yesterday, to be understood, could have serious reputational consequences, and fairness may well, in those circumstances, require the point to be put to the witness. And there is, in this respect, a distinction between, on the one hand, attacking the witness, either their integrity or their basic competence to give the evidence, an allegation that they're incompetent and they're unable to address the matters, and on the other hand, attacking, and I use the word loosely, the report, in other words, making a submission that the reasoning doesn't lead to the conclusion for which they contend. And my Lord, the present case did not involve any attack on the integrity or any reputational attack on Professor Pennington. And it's not an example of any of the 4 types of situation revealed by the review of the authorities, which I addressed you on yesterday, in which the rule has been invoked or applied. Now, I identified those 4 categories yesterday, and that led to the question that I've been addressing from my Lord Stevens about recollection. I identified those categories as those revealed by the authorities in order to make the next submission I make, and that is that there is no support on our review of the authorities for the application of the rule, whatever its scope, in a case where there is no challenge to the professional reliability or integrity of an expert, and the court is not even invited to find that the witness is wrong, but where it is submitted that the evidence does not discharge the burden of proof on the issue in question.
Well, because the expert has written a totally inadequate, totally deficient report.
Well, it might not be...
Is that not a challenge to the professional expertise of the witness?
Well, my Lord, that's an attack with respect on the content of the report and the reasoning. In a very extreme case, it might, I suppose, come to that, but there's a difference, and I've just sought to identify the distinction between attacking the expert and making submissions, which a party is always entitled to do, on the quality, the sufficiency of the evidence. And that is what was done in this case.
There's an intermediate position, isn't there? On the one extreme, you have an attack on the competence of the expert and his probity. On the other extreme, you say it's simply making the point that the burden of proof is not discharged. But in between, there's a situation where there's an attack on the conclusions drawn by the expert.
Well, my Lord,
which side of the line does that fall?
Well, an attack on the conclusions, my Lord. All that we were saying, and therefore we fall on the right side of the line, was that the conclusion did not follow from the reasoning.
I understand that that's what you say about this particular case.
Yes.
Just to test the proposition. Where does the line to be drawn?
Well, if you were going as far as to say that this reasoning is so nonsensical, it's such rubbish, that the conclusion must be wrong, and inviting the court to find it was wrong, then you would cross the line. I would have to accept that.
So it's a question of degree.
Well, but my Lord, that's exactly what this rule is about. It's always going to be a question of degree if it applies. But in my submission, you don't get as far as the question of it applying if you do not ask the court to find that it was wrong, and you accept, which was the effect of my learned friend submissions, that it might be right, it might be wrong, but the reasoning does not lead to or support the conclusion. He didn't need to go any further than that. And it didn't go any further than that. And we'll see in a minute that was the way that Lady Justice Asplin and Lord Justice Nugee looked at it and accepted that that was open to my client. My Lord, just briefly, because we've touched on authorities and the categories of cases, in his printed case and in oral argument, my learned friend has cited a number of decisions which I think I can fairly summarise as involving variously conflicting evidence the need to put a positive contrary case. Now that's Nargle, which is at 353, I think. In the expert context, it's also Reed and Kerr, which I'll come back to in a moment, but also challenges to credit, and in one case, the express rejection of cogent and well-reasoned expert evidence without giving any reasons, and that's the In Re B case, which was the dismissal of 2 radiologist experts' evidence, which the judge actually found he couldn't fault, but nevertheless rejected because he preferred some oral evidence given by, or some evidence at any rate, given by a mother and another relative in relation to the condition of the child in the week preceding the event in question. Now, my Lord, can I just take you briefly back to Reed and Kerr, because you weren't shown all of it. It's at 635. My learned friend invited you to read it at your leisure and suggested you might enjoy reading it, and you may therefore have done so, so I hope I'm not wasting the court's time. But can I just take you to this as an example of the need to put a positive contrary case in the expert context? So can we start at page 638? Third paragraph down. The first question is whether in substance the principle in Brown and Dunn were complied with. The question arises with respect to the testimony given for the defence by Mr. Milne, a pharmacist, and by a Miss Eardley, a retired botanist. The purpose of this evidence, as I read it, and as I understand Mr. Retallick, was to prove, at least as a reasonable possibility, that what was once regarded as a single species, denominated Cannabis sativa L, is now regarded by a respectable body of scientific opinion as comprehending 3 types. And then just reading on from 2 or 3 lines down, the scientific evidence to support these propositions was given by the 2 defence witnesses. Mr. Milne, in briefly given testimony, stated that on the assumption that there were more than one type of cannabis, the chromatography test could not be used to distinguish between them. Miss Eardley gave evidence at much greater length. Her testimony covered 80 pages of transcript. And then dropping to the next paragraph, the status of Miss Eardley's testimony is open to question. She seems not to have advanced the propositions referred to above as her own. Rather, did she act as a scientific reporter who presented her material as an expert marshalling of relevant scientific views. But whatever the status of that testimony was, and whatever conclusion may ultimately have been reached by the learned special magistrate about it, it is as plain as can be that the cross-examination of the prosecution expert fell far short of what is demanded by the principles enunciated in Brown and Dunn. And then Mr. Retallick submitted that all that was necessary was to put, was in fact put, and there's a recitation of what was put, and then we see at the next page, 640, in the first full paragraph, with all respect to Mr. Retallick, that submission is wholly misconceived. All that was done was to have the witness, Mr. Smith, affirm the conclusion that it was the defence's aim to refute. Not one word was put to Mr. Smith of the vast mass of material referred to by Miss Eardley and relied on by the defence. And my lords, if I can then finally just take you, because you were shown some of the intermediate passages, to page 643 to see where this ended up. About 8 lines down, it is manifestly unfair to leave unchallenged part of a witness's evidence and then through another witness called by the side, represented by the cross-examining counsel, to suggest that something that is contrary to the first mentioned witness testimony or which has never been covered by him. So that's a failure to put a positive case based on very comprehensive expert material to a witness, and that was found to infringe the rule. My Lord, the complaint about Professor Pennington's evidence in the present case was not, as I've already submitted, that it was necessarily wrong. And that was recognised by the Court of Appeal. And I know my lords will have read with care the judgment, but can I just take you very briefly to the 2 relevant passages at 129 paragraph 51 of Lady Justice Asplin's judgment. In any event, in my judgment, Judge Truman did not decide that Professor Pennington's report was wrong in the sense of expressly rejecting his conclusions. She decided that the report was insufficient to satisfy the burden of proof in relation to causation, which fell upon Mr. Griffiths because of its...
What was Professor Pennington's conclusion?
Well, Professor Pennington's conclusion was the one line that it was, I summarise, I paraphrase, it was the ingestion of contaminated food that caused his illnesses, plural. But
wasn't that expressly rejected?
Well, my lord, no. His evidence taken as a whole, both the conclusion and the reasoning leading to it, was found insufficient to prove the case. If one looks at that in isolation, I see what my lord is saying, but one has to look at his evidence as a whole. The court can't simply disregard an affirmative conclusion if what precedes it manifestly undermines it.
But look at what Lady Justice Asplin has written in the first sentence of paragraph 51. Is or is not that sentence accurate? Did they not expressly reject the conclusion that on the balance of probabilities, the claimant's condition was caused by giardia, which in turn was caused by the ingestion of food or liquid in the hotel?
No, my lord. Her Honour Judge Truman did not reject that. She found that the case, supported by the expert evidence, did not prove that on the balance of...
How can you find that didn't prove the case without rejecting it? I just don't understand how they can be put into two different conceptual categories. It's been my problem from start to finish.
Well, I appreciate that.
It's been my problem from start to finish in this case.
I appreciate that, my lord, but it's very difficult to talk about this in the abstract, but a witness or an expert can give evidence of various matters, all of which are said to lead to a conclusion. If not all of those matters are actually sufficient to lead to that conclusion, then it does not follow. I mean, if one were to take...
It doesn't follow, and the conclusion therefore is rejected.
That's right. The reasoning was insufficient, and the additional words that you add in is, and therefore reject the conclusion.
But not in the sense, as Lady Justice Asplin is at pains to point out, in the sense of expressly rejecting it, i.e. finding that the professor was definitely wrong because it was something else.
That's wrong on the balance of probabilities.
But that's not just a semantic difference, that's a real difference in my respectful submission.
Anyway, there's another passage as well as paragraph 51, which you wish to refer to.
My lord, there is. It's page 134, and it's paragraph 67. Simply for completeness, the third line starting towards the end, as I've already mentioned, it was not being suggested that the professor's report was necessarily wrong in any way, just that it did not enable Mr. Griffiths to satisfy the burden of proof as to causation. As part of a fair trial, it seems to me that it was essential that Judge Truman engaged with those submissions and so on. Now, my lords,
Well, we know Lord Justice Bean didn't agree with that at paragraph 96.
No, he didn't. But my lord, can I was going to come back to this in due course, but can I perhaps just take you to paragraph 89 of Lord Justice Bean's judgment at 138, where in the fourth line, Lord Justice Bean says this: if Professor Pennington had, for whatever reason, been unavailable to attend for cross-examination, or had attended for cross-examination and added nothing to the reasoning in his report, despite being challenged on his conclusions, then I would agree that Judge Truman would have been entitled to dismiss the claim for the reasons given by Asplin and Lady Justice Asplin and Lord Justice Nugent. In other words, if you remove the concern he had that it was not controverted and therefore it was unfair, and assume that it was, but that the evidence stood as it was on paper, he would have reached the same conclusion. So his qualitative assessment of what there was the same, and he would have reached the conclusion that the majority reached, that they were entitled, that Her Honour Judge Truman was entitled to find the case not proved. Now,
but I think that's subject to paragraph 96. He would arrive at that conclusion for the reasons given by the other members of the court, because the professor would have been wrong. He would have rejected, quite simply, the conclusion.
Well, in paragraph 96, addressing my submission, he did, I accept, have the same difficulty that my lords are having with the distinction that I am seeking to draw, but that is actually difficult to reconcile with paragraph 89, where in terms he has accepted that in the hypothetical situation he put, he would have agreed with the majority for the reasons given. And my lord, I can't do any more than that.
Yeah.
Now, my lords, apart from the fact that the appellant fails to distinguish between, on the one hand, asking the court to reject, in the sense of positively reject, expert evidence, and on the other, to find that the evidence does not satisfy the burden of proof, there are a number of other fundamental problems, I respectfully submit, with the appellant's approach. First, the appellant fixes on Lord Morris's exception in Brown and Dunn, the evidence described by Lord Morris as so incredible and romancing a character, without recognising that Lord Morris put forward the exception in the context of a rule formulated, as I sought to demonstrate yesterday, to meet unfairness inherent in impeaching a witness's truthfulness, a very strong allegation, without challenging the witness. And that, of course, has no relevance in the present case. Secondly, relying on Lord Morris, the appellant, I submit, wrongly imports, by analogy, a summary judgment test into trials. And in the process, simultaneously, reverses the burden of proof and imposes a higher standard than the civil standard on a defendant in a case in which the defendant does not controvert the relevant evidence, and the result is that the defendant is required to satisfy the court that the evidence is so incredible that it should be rejected. And that cannot be right, in my respectful submission, given the burden of proof which is and remains on the claimant in a case such as this.
That burden is only on a defendant if he doesn't challenge the relevant evidence in question by the procedurally available method of doing so, namely cross-examination.
But, my lord, that presupposes that I'm wrong in drawing the distinction I draw between inviting the court to reject the evidence and inviting the court to find the case not proved, obviously. But my respectful submission is that since if all you're doing is asking the court to find the case not proved, and you're not in that process, in that endeavour, challenging or contradicting the expert, it must be wrong to put you to the test of satisfying the court, so reversing the burden, that it is manifestly incredible or of a romancing character, thereby setting the bar extraordinarily high. Because it simply can't be right if you're not controverting the expert. And I appreciate this depends on the view one takes of whether we were or were not controverting the expert.
Yeah.
But that, my lords, is why as you will have gathered, in my respectful submission, one way of looking at this case is it's about the burden of proof, not about the rule in Brown and Dunn, because I say it wasn't engaged.
But if you are, contrary to your submission, controverting the expert,
yes,
then is there this attraction in the summary judgment test as a sort of analogy, which is if you can controvert the expert's conclusion without a trial, just by taking the judge to the reasoning and saying, well, it just doesn't add up to the conclusion, then in a sense the summary judgment test is all about whether you can resolve this case without the expense and delay of a trial.
Yes, it is. But
I'm not suggesting necessarily the test,
no.
But it might be helpful by way of analogy.
Arguably, but of course when you get to trial, there's an awful lot more evidence to consider. The burden remains on the claimant, and whether actually it would be appropriate to say in those circumstances you apply the same test in that situation to a bit of the evidence.
It only helps here because I don't think, did you call any evidence at all in this case? I don't think.
No, we did, well, just to clarify that, we didn't call any live evidence. We put in 2 Civil Evidence Act statements. The judge said something about the limited weight, if any, she could attach to those, and my learned friend indicated he understood that she might not be able to attach much weight to them. So it's not strictly right that there was no evidence.
But in the end, your submission wasn't that the judge should accept that evidence in preference to the expert evidence.
No.
It simply was the expert hadn't satisfied the burden of proof.
Exactly, my lord.
Which is something you can just as well argue on a summary judgment application.
But my lord, at that early stage...
I'm not saying you should.
No.
I'm simply saying that if your case isn't dependent upon any credit being given to your evidence, but simply the deficiencies in the claimant's case...
Yes and no. Once you... I see the analogy, but once you get to trial... The burden is the balance of probabilities, and therefore it wouldn't require the defendant to do more than satisfy the court that on the balance of probabilities you couldn't find that it discharged the burden. So I'm afraid I don't accept that it translates to the trial situation. I think it's, well, I don't think, I submit it's a completely false analogy with respect, for all those reasons. Thirdly and finally on this point, the problems with the appellant's approach. And this touches on something my Lord Burrows put to my learned friend yesterday. Importantly, the consequence of setting the bar for rejecting, or at any rate not accepting, as I would put it, such evidence so high must inevitably be that in some cases judges would be compelled to accept evidence which they would otherwise have found did not discharge the burden of proof to the civil standard, merely because it wasn't challenged on cross-examination. So in short, I'm sorry. So in short, my lords, the approach contended for by the appellant would be tantamount in some cases, including in my submission the present case, in the words of Lord Reid and my Lord Hodge in Kennedy, to delegating in effect the decision to the expert. And both Davey and Kennedy make it clear that that is impermissible.
So that's quite clear.
Yes.
That it's impermissible to delegate to the expert. Well, and the question, however, is what is the consequence in terms of fairness of proceedings if the defendant does not challenge the claimant's expert?
And the court still has to, as Lord Justice Nugent made clear, evaluate the evidence, my lord. Well, unless you're in the Brown and Dunn situation, but that didn't.
Well, that is the key to this case. Has there been such unfairness in the proceedings to make it an unfair trial?
Or as I would put it, has there been any? Because we're not in Brown and Dunn territory, my lord.
That's right.
Yes.
Yes.
And that's why a moment ago I said this case, on my case, is about the burden of proof, not about Brown and Dunn. Now, my lords, just to conclude
Before
on
we
this aspect.
leave that
Sorry,
point, your formulation was merely because not challenged on cross-examination. Well, the decision not to challenge on cross-examination is a positive decision made by a party.
but
so the word merely might
Well, my
be
lord,
inapposite.
of course it's a decision. It's a decision taken in the adversarial context. You could call it a tactical decision if you want. But ultimately, if the starting point is that the burden rests on the claimant, then if that decision is taken, the court has to assess the claimant's evidence, and the consequence, if it's not proven, follows. My lords, to conclude on this aspect, I'm conscious of the time, and I'm concerned that there's a lot I need to get through still, I'm sorry. To conclude on this aspect of the case, there was no imputation in my respectful submission, such as to engage the rule in Brown and Dunn against Professor Pennington. There was no challenge to his honesty or professional integrity. It was not suggested that his conclusion was necessarily wrong. In the circumstances, the rule was not engaged, and the trial judge was not only entitled, but in view of the court's essential function, as explained in Davey, required to evaluate his evidence. Excuse me. So, my lords, I'm going to move now to my next and alternative submission, which is even if the rule was engaged, contrary to my case, there was no unfairness in any event. And once I've done that, I'm going to deal finally and briefly with Professor Pennington's evidence. So, my lords, I respectfully submit that the suggestion that there was any unfairness is misplaced. And I submit with respect that Lord Justice Bean was wrong to characterise the respondent's legitimate criticisms of the reasoning in Professor Pennington's report as an ambush. It's also said against me that, according to the majority, fairness didn't come into it, didn't really come into it. Now, obviously, they took the view they took of the extent and scope of the rule in Brown and Dunn, but it's not quite right to say they didn't look at the question of fairness at all, and time doesn't permit me to take you to it, but the issue of fairness was at least considered by Lady Justice Appellant, who engaged with the arguments at paragraph 60 and 65 to 67 of her judgment. Now, my lords, where, as in the present case, the outcome of an issue, or indeed a claim, because that was the situation here, depends on the evidence of a witness, there is, I submit, a fundamental difference between, on the one hand, inviting the court to find the burden not satisfied, and on the other, inviting the court to reject the evidence, having impugned the witness, either their credit or integrity, without putting the allegation to the witness. Because in the former case, the process depends merely on a consideration of the intrinsic value and sufficiency of the witness's evidence. The question simply being, does what the witness says prove the matter in issue? In the latter case, where credit or integrity or professional competence is impugned, the invitation to the court will almost always depend on the court preferring other evidence or documents, or at any rate, positively rejecting the witness's evidence. Now, I've submitted already that there's nothing objectionable about asking the court to consider the content of the opinion in order to determine whether the conclusion is made out by what precedes it. And that is really just what follows necessarily from what may be obvious but is made clear by Davey and to an extent Dingley, and also the importance attached to reasons in Kennedy. So as Davey makes clear, a court's bound to consider the quality of the evidence to determine whether the burden of proof is satisfied. The respondent asked no more, in my respectful submission, of the court than to perform that function. And I go further. It would have been both a dereliction of the court's duty and unfair to the respondent, my client, to disregard or put to one side the inadequacies in Professor Pennington's evidence and simply find the case proven. Now, regardless of the scope, the ambit of Brown and Dunn, I submit that there was no unfairness. I do so for a number of reasons. The issues and matters required to be addressed in order to prove causation must, I submit, or at any rate ought to have been clear to the appellant and those advising him, variously from, first, Wood, which I'll take you to in a moment, secondly, the way he put his own case in his particulars of claim, thirdly, the respondent's defence, and fourthly, the respondent's Part 35 questions. And I respectfully submit, in light of all that, the appellant, or Professor Pennington, both had every opportunity to address the relevant issues, the issues which I respectfully submit needed to be addressed. Now, can I take you back to the case of Wood, please, which is at 583. 583, my lord, I'm sorry. And specifically, to the dicta, we find at the end of the case, the judgments in the case, which emphasise that proving a claim of the sort made by the appellant in that case and of the sort made by the appellant in this case is not easy. Now, you were taken to parts of this. Can I just take you back to the judgment of Lord Justice Burnett at 595, paragraph 29, dropping down about 8 lines and starting at the end of the line. The judge was satisfied on the evidence that Mr. and Mrs. Wood suffered illness as a result of the contamination of the food or drink they consumed. Such illness can be caused by any number of other factors. Poor personal hygiene is an example, but equally bugs can be picked up in the sea or a swimming pool. In a claim for damages of this sort, and this was just such a claim, the claimant must prove that food or drink provided was the cause of their troubles and that food was not satisfactory. It is well known that some people react adversely to food or different water and develop upset stomachs. Neither would be unsatisfactory. That is an accepted hazard of travel. Proving that an episode of this sort was caused by food which was unfit is far from easy. It would not be enough to invite a court to draw an inference from the fact that someone was sick. Contamination must be proved, and it might be difficult to prove that food or drink was not of satisfactory quality in this sense in the absence of evidence of others who had consumed the food being similarly afflicted. Additionally, other potential causes of the illness would have to be considered, such as a vomiting virus. And then, my lords, you weren't shown, I don't think, forgive me if I'm wrong, what Sir Brian Leveson said at 34 at 596.
I think we were.
I'm so sorry. It's only I do apologise. It's only the 4 lines starting in the second sentence, concluding that alternative explanations would have to be excluded.
Yes,
now, I do apologise.
Yes,
Can you remind me, in that case, was there any identification of pathogens in the claimant's body?
My lord, I'm ashamed to say I can't answer the question immediately. It may be that Mr. Weir is able to, having been in the case, but...
Because what seems to be being discussed by Lord Justice Burnett is a concern that package tour operators are being put under an unreasonable burden in the context of what's described as strict liability when someone has an upset stomach. I wonder if this was a case where a pathogen had been identified.
No. My lord, I just had a look as my learned junior. We don't think so, is the short answer. But I don't accept that is a fundamental distinction for reasons I'll come to, because we're going to see that giardiasis which was the pathogen which certainly Professor Pennington got closest, at any rate, to identifying as being the offending cause, can be contracted in ways other than through consumption of food and drink.
Yes. Well, I think the claim itself suggested that it might be the swimming pool.
Well, yes, and I'm just going to come to that very briefly in a moment.
Paragraph 6.
I'm told paragraph 6 makes, and I'm right, am I? Yeah, and I am right.
Suffered a bacterial infection of some sort.
I'm grateful.
Paragraph 6.
Yes, paragraph 6, suffered a bacterial infection of some sort. One sees 3 lines from the bottom. Thank you very much.
Yes, so it was identified as bacteria.
As bacteria, but not a specific one. So it wasn't Campylobacter or some other particular bacteria. Now, my lords, the points that I seek to emphasise, which are, I submit, of general application, are the observations by, respectively, Lord Justice Burnett and the President, that other potential causes would have to be considered and in Lord Justice Sir Brian Levison's judgment ruled out, because that can only be addressed by expert evidence. And for that reason, addressing those questions is required of the expert. Now, that was so, despite picking up on my Lord Hodges' point. That was so, notwithstanding that there was a positive stool sample in the sense that a pathogen was identified. But of course, even if it did make it a different type of case, which I don't accept, we're not talking about one pathogen being identified. There was a positive stool sample, but it was very much complicated by the fact that it was positive for 3 different organisms. Now, can I develop the next bits of my argument by reference to my written case, because I am concerned that I'm otherwise going to run out of time. I've sought to rely upon variously the particulars of claim, the defence, the Part 35 questions, and so on. At paragraph 35 of our written case, we make the point that the claimant had himself put other possible sources of infection in issue.
Just give me a page number.
Yes, 102.
Thank you very much.
So sorry. We make the point that the claimant had himself put other possible sources of infection in issue, and we enumerate the allegations made in relation to things other than food or drink. There was actually only one generic allegation in respect of drink, in numbered paragraphs 1 to 8, and I'm not going to read them out. My lords have them and can read them in due course. But the point is there were a lot of other possible causes identified. Further and significantly, in my submission, the appellant expressly recognised, and this is paragraph 14 of the particulars of claim, which is at 192, that he might be unable to prove the precise act or omission which caused the illness. And he went on to prove that in that eventuality, I quote, it will be averred that it is more likely than not that the effective cause of the illness was acts and or omissions of the defendant. So, my lords, that's the way the case was put. The respondents in its defence, and this is paragraph 37, so back at 102 and following in my printed case, the respondent in its defence likewise put in issue or raised the possibility of there being other possible causes, and those are enumerated in 5 numbered paragraphs. We actually went as far, or my learned friend did, as to draw attention to paragraph 29 of Lord Justice Burnett's judgment in Wood, and set that out in paragraph 14C of the particulars of claim. My lords, next, it's relevant to note the terms in which Professor Pennington was instructed, which I did allude to yesterday, but his reports at 206 And paragraph 1, which recites the terms of his instructions, is at 207. And one sees that he was instructed 1, comment on the chronology of events, 2, provide a detailed commentary on the issue of gastric illness and any breaches in the health and safety procedures in place at the hotel, and then to confirm as to whether on the balance of probabilities the illnesses, I note the plural, in question were caused as a result of staying at the hotel in question and a breakdown in the in the health and hygiene practices, so generally in the hotel. That he was instructed in those very broad terms is unsurprising in my submission, given the numerous and different ways in which the case was pleaded, which you've just seen. What is more surprising and fundamental in my respectful submission is that he did not refer to any of the various allegations made in the particulars of claim, which identified a number of different potential sources of infection, and he'd had the particulars of claim when instructed in those broad terms, before coming to the conclusion that he did. Next, my lords, there are the Part 35 questions, and those are at page 210 of the bundle. And you've already seen those, or been shown those, and it's questions 4, 6, and 10, which we particularly rely upon and are set out in the Statement of Facts and Issues, asking variously whether there would be a range of opinion. And that, my lords, might be thought, given the way the case was put, to embrace a range of opinion as to possible causes of infection. And my learned friend has suggested that the question was answered simply by him saying, I can't rule out that there were 2 infections. Well, it was potentially much broader than that, the scope for a range of opinion. To what extent? I'm sorry.
Range of opinion is something of a term of art in this context, isn't it? It's talking about
different views,
medical or other expert scientific question about which there is disagreement among competent scientists and experts.
It can also mean,
rather than something which is totally focused on the facts of a particular case.
Well, my lord, I wouldn't accept that it was as narrow as that. What I would submit is that it is directed at getting from the expert an acknowledgement, if it be the case, that there is a range of opinions in the case, or there could be, on the facts of the case. For example, as to what the diagnosis was in a case where there's differential diagnosis. There could be a range of opinion on the facts of the case, the presenting symptoms and signs, as to what the diagnosis is, if that was the issue in the case. So I would respectfully submit that it clearly embraces a range of opinion in the case, as well as the sort of more academic range of opinion point that my lord put to me. Then the next question is that we rely upon is question 6. To what extent a finding that the appellant had eaten outside the hotel might affect Professor Pennington's opinion on causation? And in that regard, my Lord Hodge made the point, well, he said it would depend on the frequency, and he only had one meal or part of a meal outside the hotel. If one actually looks at the answer on 232, if the claimant had eaten outside the hotel, several things would be considered. The nature of the food and the date or dates.
This is answer to question
6, my lord.
The nature of the food and the dates of consumption and frequency. Yeah.
Dates of consumption, including date or dates, so therefore potentially a single date, and the frequency of its consumption would be taken into account. Now, it's not, we complain, it's not an answer to the question, because it simply says what would be considered. But putting that to one side, with the greatest of respect, my lord, I wouldn't accept that it is as simple as being able to rule out inferentially the possibility that the meal eaten outside the hotel could have been responsible for a second infection contracted after that meal because he only ate there once. And, well, as we all know, that one piece of chicken or one egg contaminated with salmonella is quite enough to cause.
Do you have to rule out all possibilities, other possibilities, in order to come to a conclusion on the balance of probabilities?
Not necessarily identifying every single one and ruling them all out seriatim, but you do have to, I'm sorry, my lord, you do have to advert to the other possible causes, and there has to be some chain of reasoning when there are real alternatives. And we'll see in a moment that there were real alternative causes. Sorry, Mike.
Why is it unacceptable on a relatively low-value claim not to look at the claimant's evidence and on the assumption it's correct, he ate frequently at the hotel and may on one occasion and also impugns the hygiene standards of the hotel, and yet on one occasion somewhere else, and there is no evidence whatsoever as to the hygiene standards of that other place. Why, in that context, when you're addressing the likelihood, and no more, just the likelihood of the cause, can you not say, well, we know he ate frequently in a place where the standards were being criticised, and he ate once in a place where we know nothing about the hygiene standards.
Well, if that was all the case was about, and there was nothing else, that might, and I say no more than might, be a way of a judge reasoning to a conclusion in favour of the claimant. But of course, in this case, it was rather more complicated by a lot of other factors, including 3 different pathogens, including, as we'll see in a moment, other possible causes or modes of acquisition, and including, I respectfully submit, the fact that the answer that the professor did give, to the extent that he answered the question, did not only identify as relevant frequency, but clearly identified the date or dates. Now that must mean that depending on when, for instance, he fell ill, and when he may have eaten on even a single occasion, there might be scope for making a link. But we don't know, it's speculative, my lord.
But,
my lord.
But the fact is, the defendant chose to investigate none of these matters whatsoever.
But equally, the fact is, my lords, if I'm right, as Wood makes clear, the burden is on the claimant.
Of course the burden is on the claimant.
There are, but more than that, with respect, my lord, there are other causes in these types of case, and again, I'll show you something about that in a moment. And there has to be more than, in the context of the claim being put in the way it was, in the context of Wood, a report which, without any reasoning addressing other possible causes, comes to an almost bald conclusion, certainly a conclusion following exiguous and lacking reasoning, that the illnesses, plural, about which I'll also have something to say, were contracted as a result of eating contaminated food without even mentioning the other things, which he was specifically asked to consider. My lords, the third question in a moment will take me to the evidence of other causes that was before the court, and that related to the various publications which he was asked in a question to comment on. The question is at page 211. Please find attached the following. They're set out with links. Do you consider the content of the above publications to be reliable sources of information? If not, why not? Now, my lords, I'll come back to them, if I may, in the context of my consideration of his evidence. But suffice.
Again, he says these publications are reliable, or I can't remember what words he used, but he accepted
reliable sources.
Reliable sources of information.
Yes, he does.
But he was never questioned about any of these sources, these documents. These documents were never put.
They weren't put to him orally, but he was given them. He was asked whether they were reliable sources.
Yes.
And when one looks at what they say, by answering yes, it must follow that it has become part of his own evidence that there are other ways in which you can contract giardiasis, because that's what they say.
I don't think anyone is denying that there are other ways that you can get giardia.
But that's important, my lord, because he didn't give them any consideration whatsoever.
If the cross-examination had consisted of, do you accept these publications to be reliable sources of information? And the witness answered yes, and then the cross-examiner sat down, it wouldn't lead anywhere.
Well, my lord, I'm not sure with respect that that's necessarily correct. If the document itself is a document in the case
it's far
of
more useful to point to a particular part of the document
Yes.
and say, do you consider this particular part
Yes.
and this particular aspect and how it impacts on
Yes.
these particular facts?
Yes.
And that wasn't done.
Well, maybe not, but that might have been a matter if he'd been there giving oral evidence for re-examination. I mean, for our purposes, we put a question to him based on what we considered to be an exiguous report. He's provided answers in three respects to three different questions which are, in our submission, unsatisfactory. All of it simply feeds into the submission we made that it doesn't discharge the burden of proof. And, my lords, as to, I mean, each and every one of them were very short documents. And one example is at 223, the NHS document, how giardiasis is spread. There are lots of ways you can catch giardiasis, such as drinking water, water getting into your mouth while swimming, and there were allegations about the swimming pool, eating food, I accept, of course, touching surfaces that have been touched by an infected person, and there were allegations about absence of hand gel. And similarly, at 221, the government.uk guidance, under transmission, giardiasis can be transmitted by, and there's another means here, direct contact with infected animals or humans, so person-to-person contact, and then there are others which overlap with the ones we've seen in the NHS document. Well, it wasn't a satisfactory answer when, in his report, he'd not addressed any alternative causes, given that the claimant had raised some of the exact means of transmission identified in these documents that he said was reliable in his particulars of claim. But, my lords, my fundamental point on fairness, assuming against myself that the rule was engaged, is that both individually and in combination, these Part 35 questions and the other matters to which I've drawn your attention, the guidance in Wood, which was pleaded, the particulars of claim, the defence, and the answers to the questions, in combination, gave the appellant and the expert every opportunity to address alternative causes, and that simply wasn't done.
How about at 221? Are there any figures for the potential transmission by contact with infected animals or humans?
No, and I'm not suggesting infected animals is a realistic submission in this case, my lord. No, there aren't. But humans...
Well, as far as we know, there aren't. But the professor might have said, well, the overwhelming transmission is by food and beverage.
But my lord, one's speculating.
Know,
That's exactly the problem with his evidence.
Exactly why one cross-examines.
But yes. Well, I respectfully put it differently. That's the problem with the evidence and why we were entitled to invite the court to find burden not satisfied.
But if, and we're dealing with the hypothesis that the, whether we call it the rule in Brown and Dunn, or whether we say that it was the Phipson text applies, then one aspect of that is allowing a witness to explain his or her evidence. And all these matters could have been covered, perhaps in quite a forceful cross-examination, but the defendant chose not to do so. Now, the defendant's counsel may have been put in a very difficult position because of the inability to get an expert report in, or because of witnesses to fact not being able to be contacted.
Well,
but at the end of the day, a decision was made not to cross-examine.
My Lord, I accept that. I mean, my Lord, I do accept that, that decision was made. My Lords were taken to Chiltern and Saga Holidays, which is at 834, and at 837, between letters B and C, my learned friend drew attention to the passage which reads,
Yes.
it's basically an adversarial system, and it's fundamental to that each party shall be entitled to tender their own evidence, and that the other party should be entitled to ask questions designed to probe the accuracy or otherwise. But of course I accept that. But this isn't authority for the proposition, and it is not the law that a party is compelled to do either of those things, tender any evidence or cross-examine. And it is, as the counterweight to this, a fundamental aspect of our system that the burden of proof is on the claimant. And it is always, therefore, open to a defendant to submit that the claimant has not discharged the burden of proof. Whether the court accepts that, of course, depends upon an evaluative assessment of the expert evidence. But it was not my client's job to point out by calling, and I'll come to that in a moment, making an application for him to come and give evidence, lacunae or inconsistencies in the evidence, if it wanted and chose simply to submit that the case was not proved. And there's nothing unfair to a claimant about a court acceding to a submission that the evidence which the claimant has chosen to put before the court does not do the job for which it was intended. Now, my Lords, I said I'd just deal briefly with the question of attendance for cross-examination. I do that for this reason, in case the context is in any way important to your Lordship's ultimate decision and judgment. Lord Justice Bean, at paragraph 89 of his judgment, which is at 138, said this: "This was a multi-track trial where there was no requirement, as there is on the fast and small claims track, CPR 35.5, for a special order that experts should give evidence orally. The default position, therefore, was that witnesses would have to attend for cross-examination if requested to do so." Now, I don't accept that that is quite the right analysis with respect. Well, my Lord may seem surprised by that, but there's a reason for that. The way he puts it is, we'll have to attend if they're required to. Or requested to, I think, requested to. Just so that it's clear, can I take you to Rule 35? And you've got that in the authorities at 244. Now, Rule 35.5, sub-rule 1, which is at 249, provides that expert evidence is to be given in a written report unless the court directs otherwise. In other words, oral evidence is only permitted with the court's permission, and that's a general provision of general application. Rule 35.52 then provides that if a claim is on the small claims track or the fast track, the court will not direct an expert to attend a hearing unless it's necessary to do so in the interests of justice. thereby effectively establishing a presumption that will need to be displaced in the exercise of the court's discretion in the event that a direction is sought for an expert to attend in a small claim or a fast-track claim. The rules, however, make no specific provision for cases on the multi-track, which must therefore be subject to the general rule set out in 35.1, which is at 244, that expert evidence shall be restricted to that which is reasonably required to resolve the proceedings, with any application, because it would require an application in the light of 35.1 and 35.5, to be considered by reference to the overriding objective, I would submit. Now, that analysis is consistent with the listing questionnaire as well, for what it's worth, that you've been shown, and which we have at
But the 35.1 isn't talking about whether it's written or oral, surely. It's talking about what evidence and what types of evidence are necessary to resolve the proceedings, or reasonably required.
no, I entirely accept that, but 30...
The rule man isn't thinking about distinguishing between somebody turning up and verifying his report orally and...
No, I accept that, my lord. I accept that. It's general provision. But when one looks at 35.5 in light of that general provision, what one sees at the very least is there's no specific provision, such as there is in the case of fast-track and small claims, in respect of the criterion that have to be satisfied for the purposes of persuading a court that an expert should come to give evidence in a higher value case. One has to make an application.
All Lord Justice Bean is saying is that the restriction in 35.5.2 doesn't apply to multi-track.
Yeah.
And what's wrong with that conclusion?
Well, my lord, I forgive me. I didn't mean to make more of this than perhaps I'm at risk of doing. My only submission was that it's not quite right in my submission to say, as Lord Justice Bean does at page 138 in paragraph 89, that the default position, therefore, was that witnesses would have to attend if requested to do so. My only point being that it would nevertheless, on a construction of the rules, require an application.
Why?
Well, my lord, because...
You're certain fast track, you can't do it. So therefore you can call whatever witnesses you like as far as expert evidence is concerned under the multi-track.
No, my lord, because 35.51 is of general application. Expert evidence is to be given in a written report unless the court directs otherwise. So it would require an application.
Well,
that's the only point I'm making.
The expert evidence has been given in a written report. It doesn't detract from the generally understood requirement in a multi-track case that although you put in a written report, your expert must attend to deal with any questions about it.
Well, my lord, with respect, I wouldn't accept that is the general position that prevails in the county courts in low-value multi-track cases up and down the country. It's not unusual not to have expert evidence. It's obviously quite common for there to be expert evidence as well, but it's not something that follows as night follows day, and it does, under the rules, require an application. But, my lords, I don't seek to make more of this than simply to correct what is a small error, in my respectful submission, in what Lord Justice Bean said about the provisions in that respect.
Well, I mean, is this aimed in some oblique way to say, well, it was really just the claimant's fault that Professor Pennington didn't attend?
Well, the claimant could have called the professor, subject to making...
I'm assuming his attendance was dispensed with during party-and-party correspondence.
Well, my lord, I'm not entirely sure, but I think, and we will check, that I'm right in saying that issue was not ventilated.
Really?
But perhaps that could be checked. My lords, we'll check that.
Yeah, thank you.
My lords, can I just move on now to make a point that I think I made a moment ago, but just for the avoidance of doubt. Whilst the lacunae or the inconsistencies could have been tested in cross-examination, and whilst they might have been identified in discussions, they probably would have been between experts if there'd been competing expert evidence, the respondent was under no obligation either to serve its own evidence or to make an application, which I submit it would have required, for Professor Pennington's attendance for cross-examination. Now, my lords, just to address the ambush point, far from amounting to an ambush in my submission, of the sort one's very well familiar with, where you get late disclosure of a document or production of video surveillance evidence, or an attempt to call a new witness, which would deprive the opposing party of a proper opportunity to deal with that new material. The appellant was, in my submission, on notice based on all the material to which I have drawn your attention, his own pleadings, Wood and TUI, the defence, the questions, that there were real issues which had to be addressed by his evidence, including his expert evidence as to causation. And there is a fundamental difference between providing notice of a positive case on the one hand and simply making submissions as to the quality and sufficiency of the other party's evidence. If the submissions are limited to the other party's evidence on an issue which that party is required to prove, which has been identified in the statements of case, there can be no legitimate criticism in my submission, because it was, after all, open to the other party to adduce whatever evidence it considered necessary, and the appellant in this case knew what Professor Pennington's evidence was saying against the backdrop of the pleadings and so on that I've expounded, and was, as well, in truth, better placed than was the respondent to know whether it was enough to satisfy what had to be satisfied to prove causation. And so, my lords, for all those reasons, if the rule was engaged, I respectfully nevertheless submit in the alternative that there was nothing unfair about the trial. And what it reduces to, with respect, is that it was the shortcomings of the appellant's own evidence, which led to the trial being dismissed. The claim, I should say, being dismissed. Now, my lords, I would be pleased to hear to my final submissions, which will be short. I think strictly I have until 12:15, but I hope to finish before that. And they relate to Professor Pennington. But could your lordships just bear with me for one moment while my learned friend draws something to my attention? Yes, yes. I'm simply reminded that there was no order at the case management stage relating to the relevant experts giving evidence orally. That doesn't quite answer the point about whether there was correspondence, and I've asked for that to be looked into, my lord.
Thank you.
I'm sorry, I can't answer it.
Yeah.
So, my lords, can I now?
The rule of advocacy is you should never say without first reading it that something is sufficiently covered in party and party correspondence.
Well, I hope I at least comply with that rule of advocacy, if not others.
Make no assumptions.
Yes, well. But, my lords, Professor Pennington's evidence. Now, can I, as a first point, just say this? There's been a lot said by my learned friend about the sufficiency of Professor Pennington's evidence, and there's been effectively a valiant attempt to rehabilitate it. It's very important that this court, sitting as a third-tier appeal court, has regard to what the courts below had to say. Now, in that regard, I'm not going to take you back to Her Honour Judge Truman's judgment, nor to Mr. Justice Martin Spencer's judgment, other than simply, if I may, to note that so far as Mr. Justice Martin Spencer's judgment was concerned, he did accept that there were serious deficiencies in Professor Pennington's report, and that's, for your note, paragraph 38, page 170. More importantly, can I just remind your Lordships what Lady Justice Asplin, Lord Justice Nugee, and Lord Justice Bean had to say. We have looked at these passages in other contexts, so I can do it quickly. First, page 134, at paragraph 67, which was the paragraph I took you to for a slightly different reason. Further down, so 6 lines up, she, that is, Her Honour Judge Truman, had cogent reasons for deciding that the burden of proof in relation to causation had not been satisfied, and rejected Professor Pennington's report accordingly. Her reason was set out at 18 to 22 of her judgment. She did not decide that the professor was wrong, just that his report was insufficient to satisfy the burden in relation to causation. It is not for us, nor was it for the judge, to overturn her evaluative judgment in that regard. Then Lord Justice Nugee...
Which paragraph was that? I'm so sorry.
67 on 134, my lord.
Thank you. We looked at it earlier. Yes.
We did, but we looked at the top of it, and I was looking at the bottom of it then.
Yes.
Yeah, particularly the last sentence. Yeah.
Lord Justice Nugee, at paragraph 84, which is at 137, in the second line towards the end, said, counsel for TUI was not precluded from making submissions as to the inadequacy of the reasoning in his report, and Judge Truman was not only entitled but right to examine that reasoning and to see what weight to ascribe to his opinion and whether the case had been proved. I see nothing wrong in what she did and do not consider that the judge was right to disturb her conclusion in the way that he did. He also expressly concurred with everything that Lady Justice Asplin had said, and therefore must be taken to agree that Her Honour Judge Truman provided cogent reasons. Then I have shown you, so I won't reread it, paragraph 89 of Lord Justice Bean's judgment at 138, in which, in effect, he said, if you put to one side my concern that this was not controverted and assume that the expert had given evidence as per his written evidence, I would agree that Judge Truman would have been entitled to dismiss the claim for the reasons given by Asplin and Nugee LJJ. Now, my lords, those views, and specifically the conclusion reached by the majority and the contingent view expressed by Lord Justice Bean, were views and were a conclusion in the case of the majority that, in my respectful submission, the Court of Appeal was plainly entitled to reach, or cannot be said plainly to have been wrong to reach. Assuming, my lords, it is even open to the appellants to attack in this court the report of Professor Pennington. I will deal with his report briefly in a moment, but I say assuming it's open to them because, can I just take you briefly to the Statement of Facts and Issues at 60? There's some subdivision of the issue in ensuing paragraphs, but at paragraph 47, the issue in the appeal is identified, and it's whether Her Honour Judge Truman was entitled to find that the appellant had not proved his case on causation, even though Professor Pennington had given uncontroverted evidence that the appellant acquired his gastric illness following the consumption of contaminated food from the hotel. So that's how the issue was expressed, not whether or not she was right to come to the conclusion she did having regard to the content of the report or anything of that sort, let alone the Court of Appeal, I suppose that's the way it would have been put, was right to affirm her decision in that respect. Just for completeness, one finds, because I should take you to them, the grounds of appeal at 28. Paragraph 31, the Court of Appeal, majority, erred in law in that it wrongly held, 1 and 2, perhaps I can invite you to read to yourselves, because I don't think they are germane to this. And then 3, the trial of this action was not rendered unfair by the court's rejection of the claimant's case due to the perceived insufficiency of reasoning of the uncontroverted expert evidence. Now, apart from anything else, that clearly is focusing on the question of fairness, but it also has to be read in the light of what follows and as subject to 32.1. The appropriate test to apply, as held by Lord Justice Bean, is that 1, the trial judge is generally bound to accept the uncontroverted expert evidence. So, my lords, there isn't, in my respectful submission, a ground of appeal to the effect that the Court of Appeal was wrong to find that the judge had cogent reasons for deciding as she did, and nor was it identified as an issue in the statement of facts and issues. But putting all that to one side, can I nevertheless briefly, by reference to my case, address you, and I will do it briefly, I promise, in relation to the expert evidence and subject to the submission I've just made. We address this in our printed case at paragraph 46, which is at 105. And we make a number of points. So first, that he accepted as a possibility that the appellant contracted 2 separate infections. And we draw attention to the fact that he said that at the beginning of his report in paragraph 4. And we say, whilst he did not develop this, his conclusion in the final sentence of the same paragraph referred to gastric illnesses, plural, and submit that his evidence was therefore internally inconsistent. Now, my learned friend had a go at suggesting how one should read the references to infections and illnesses, but it's at 208, the report. In the beginning of that paragraph, the possibility cannot be ruled out that Peter Griffiths had 2 infections. That can only mean 2 separate infections, each of which would or could have had consequences in terms of symptoms. And then at the end of the paragraph, on the balance of probabilities, Peter Griffiths acquired his gastric illnesses, plural, following the consumption of contaminated food or fluid from the hotel. Now that can only sensibly be read as 2 separate illnesses, or at least more than 1 illness, my lords. I mean, it could be a mistake, but it's simply inconsistent on the face of it. Now, my lords, the second point we make is that the possibility of 2 infections, or 2 illnesses, was moreover consistent with the multiple pathogens detected. So there were 3 pathogens, 2 viruses and 1 parasite. The fact that, according to Professor Pennington, it was unlikely that the appellant had been simultaneously infected with Giardia and the 2 viruses, and consistent, moreover, with the appellant's own history of being ill, recovering somewhat, and then becoming ill or more ill again some days later, after eating the food that he consumed part of, the meal he consumed part of away from the hotel. Now, I won't develop that point any further. The next point we make is that there was a gap in his reasoning in respect of incubation periods. Now, I mean, that simply is because he does not address in his report either the possibility of infection acquired pre-arrival, the burger meal eaten, or the subsequent meal about which I made submissions in relation to question 6.
Before we get there,
Yes,
you make the point that the discharge report identified a parasite and 2 viruses.
Yes.
But he did address the question of whether a virus was likely, where you said that the absence of vomiting.
Well, my lord, we addressed that in subparagraph 4 on 106, where we say that he suggested that a viral cause was much less likely than a bacterial one, but he didn't explain how the 2 viruses were found in the stool sample. That's the first point. Or why they could be discounted. That's the second point. Or third point, how even if a viral cause was less likely than a bacterial one due to the absence of vomiting, that fitted with the fact that only parasites and viruses were found in the sample, not bacteria. I'm reluctant to put it colloquially, but it was all over the place, is my respectful submission.
Well, but I mean, again, none of this was explored on cross-examination.
I of course accept.
My understanding is that while a parasite is different from bacterium, both are treated, for example, by antibiotics, so they are different, but they have similar treatment.
Well, my lord, I'm perfectly happy to accept that from my lord. I don't know, my lord.
No. Well, I mean, I just
I'm
wonder
not sure
how much we can explore these matters.
Well,
it hasn't been explored before the judge.
But my lord, you can't, but nor could Her Honour Judge Truman, and that's precisely why we said the case didn't come up to proof. My lord's question is obviously directed at why we didn't cross-examine on it, but my answer is because we didn't have to. My lord,
how frequently does one find viruses in stool samples coincidentally?
My lord, even if I did have anecdotal evidence to answer that, and you permitted me to give it, I'm not sure how helpful it would be, but I don't know is the answer. I don't.
I would like to have known what Professor had to say.
Your Lordship might, and might have been very interested in that if you'd had before you the Professor giving evidence, but the court wasn't presented with that option. The court had to try the case on the basis of the evidence before it. My lords, I'm going to get there, forgive me. Just 2 final points. He did not say why any of the non-food related possible causes should be discounted, and I've already effectively touched on that. But that, I emphasise, was very surprising in the light of the way he was instructed. And it was the more surprising given the publications, which I won't go back to, which I showed you. By virtue of his acceptance of those as reliable sources, I respectfully submit that Professor Pennington's own evidence raised other possible causes which he did not consider. And my lords, insofar as it said, well, he wasn't asked about that, I do simply make the observation that my learned friends also referred to that material in inviting you to consider the occurrence in Turkey and where Turkey ranked in the table of cases for giardia. So in the real world, this was material before the court. Finally, my lords, I submit that contrary to Mr. Justice Martin Spencer's finding, the Professor did fail, as the majority accepted, to answer the important Part 35 question about the range of opinion, which I submitted in response to my Lord Briggs, extends beyond simply the academic and does include the range that might have been open in the case. And I gave the example of a differential diagnosis, potentially different experts faced with the same symptoms and presentation coming to different conclusions, and it being the duty of the expert in those circumstances to draw that to the court's attention. My lord, would you give me just 1 moment, please? My Lords, I'm grateful. Unless I can assist the court further, and with my apologies for using up almost every minute of my allotted time, despite the indication you gave yesterday, those are my submissions.
Well, Mr. Stevens, you faced a lot of questions, and it was your allotted time, so you don't need to apologise for that. Thank you very much. Mr. Weir.
Please, the court. Can I start and deal briefly with the issue of how the trial judge rejected the opinion evidence of Professor Pennington? There will be cases where a trial judge is not provided with evidence which supports the claimant's case. And a good example of that actually can come out of this case. You've heard how, in the particulars of claim, a number of possible causes of the claimant's illness were raised, or modes of transmission, in other words, by swimming pool, by other means than food and drink. That's how the case was pleaded, and then we have the defence. And then the claimant receives a report from Professor Pennington in which he gives his clear opinion, as the court has seen already at page 208, that the cause of the claimant's illnesses was food and drink from the hotel. So if the claimant at that point had ignored the evidence of Professor Pennington and proceeded to trial on the basis that the cause of the claimant's illness was using the swimming pool, there would have been no expert evidence to make good the claimant's case on causation. And it wouldn't be so much that Professor Pennington's report is wrong, it would be his report, whatever it is, but it just doesn't support the case you're seeking to promote at trial. And that would be an unusual, because I'm not quite sure how the claimant would do that, but that would be an example of the claimant pursuing a case that the claimant cannot prove. And furthermore, following that which is set out by Lord Justice Dyson, if you go back to page 68, please. This is in our case for convenience rather than the case. The case is in the bundle and the reference is sidebarred in our case, but you can just see the quote, in which D, so near the top, we set out that the trial judge's role is limited to determining the issues as framed by the parties, so that the judge may be compelled to reject a claim on the basis on which it's advanced, although he or she is of the opinion it would have succeeded if it had been advanced on a different basis. So if the claimant had said, we eschew the opportunity to pursue our case on the basis of food and drink, don't ask me why, but if that's the step that had been taken, then there you would see working the application of the principle which Lord Justice Dyson set out in Al-Madini, because the court couldn't make good the claimant's choice to limit that which the court was asked to resolve at trial. And then you could also see the application of the burden of proof. Because that's a case where the trial judge does not have to reject the expert evidence in order to find the claimant's case is not proven. Rather, the trial judge will find that the expert evidence taken at this simply doesn't establish causation on the basis of the swimming pool. And so the claimant's claim will have failed for failing to discharge the burden of proof. And can I then distinguish that pretty unusual category of case from a case whereas here there is clear expert evidence which does support the claimant's case as promoted at trial, which is obviously in alignment with the expert evidence of Professor Pennington on causation, namely that the cause of the claimant's illnesses was consumption of food or drink at the hotel. And in that situation, there is no way around the opinion evidence clearly expressed of Professor Pennington. There's no way around it. You either have to defeat the claim by rejecting the expert evidence, or the expert evidence, which inevitably has the effect of discharging the claimant's burden of proof, has to be accepted. It's not a burden of proof case. It's the submission I've made yesterday. It's a accepting or rejecting the clear opinion of Professor Pennington, which makes good the claimant's case on causation. Please. Can I now come to the role of the trial judge? part of the respondent's submission.
You say accepting or rejecting it. I mean, if Professor Pennington had been cross-examined, and if he hadn't answers for the criticisms which were made and persuaded the trial judge, do you accept, as Lord Justice Bean said, that the claimant's case would fail?
The only route by which the claimant's case could fail if the claimant's evidence is controverted by way of cross-examination at trial is by rejection of the opinion evidence which he sets out, unless he himself walks away from his opinion evidence during cross-examination. You can have that happen, that does happen. A claimant's expert during cross-examination will say, well, now you put it that way, I no longer hold my opinion.
You don't have to go that far. You just have to persuade the judge that the opinion evidence is wrong by virtue of cross-examination. You don't have to get the witness to say,
no, my Lord,
say, by the way, I am wrong.
That's a good day in court.
Yeah.
That's a 1 in 100 day, isn't it?
That's the one. That's
just an average day in court. Just another day. I'm just saying that sometimes you don't have to say the expert's wrong, because the expert himself has said he's wrong. That's all. That's the only point I was trying to make. He's walked away from his own evidence. Yeah. But absent that, what you have then is the ordinary trial process. And the whole point is you're then having, this is a submission I made earlier, material, addition to the material in the report upon which the judge makes his or her assessment and evaluation, because you have answers. And even if the answer was complete silence, that of course is an informative answer. If it's repeated silence to a series of acute questioning by defence counsel, that will enable, obviously that would be then matter for the trial judge, subject to issues on appeal that this was a decision by the trial judge that no reasonable trial judge could make, etc., that would enable the trial judge to determine, exactly as by Lord Stevens, that the opinion evidence as expressed in the report should be rejected. Forgive me for the length of that answer, but that I think is our position. My Lord, I was then turning to the role of the trial judge, and part of the respondent's submission was premised on the following. In a case, what I'm going to call the standard case, where both parties adduce evidence at trial which is in conflict, and all witnesses of fact and expert opinion are cross-examined, the role of the court is to evaluate all of the evidence and to decide what weight to attach to it. And reference was made, as this court will recall, to Lord Justice Nugie's judgment at paragraph 81, page 136, which we don't need to turn up. The second part of this submission which was made was the role of the court is just the same when the claimant adduces uncontroverted expert evidence. And as this court knows, by uncontroverted I mean not in opposition to factual evidence, not in opposition to written expert evidence, but nor is there cross-examination of the expert. That's our definition of uncontroverted, which we've always sought to set out early doors so that there's clarity on that. It's also in the SFI. And our response is as follows. Certainly, in the standard case, the court, faced with conflicting evidence, all subject to cross-examination, is charged with the task of making a decision, that is, resolving the conflict of evidence. And only exceptionally will the court be entitled to dispatch a disputed issue by resort to the burden of proof. And that's me quoting from Mr. Justice Wilson, as he then was, in the Stevens and Cannon case that we've referred to at our paragraph 7, but which I'd briefly now, if I may, for the first time take the court to. So that's page 1226, 1226. And although it's Court of Appeal rather than House of Lords, and although the judgment was given by a then High Court judge, this when one goes to textbooks, is taken as the case in relation to discharging the burden of proof. Cases all come back to Stevens and Cannon, and to that which then Mr. Justice Wilson had to say, which you can see at paragraph 46 at the bottom of 1226. And you'll see at little a, he says, the situation in which the court finds itself before it can dispatch a disputed issue by resort to the burden of proof has to be exceptional. And I'm going to leap to C, the exceptional situation which entitles the court to resort to the burden of proof is that notwithstanding that it's striven to do so, it cannot reasonably make a finding in relation to a disputed issue. And the case, or both cases, in fact, Davey and Dingley, but I'm just going to look at Dingley because the facts weren't drawn out in Dingley, but Dingley in the Chief Constable's Strathclyde and indeed the Davey case, and the learned friend attached so much weight to it at the beginning of his submission, provide good working examples of this. So if we just go back to the Dingley case, and to page 374, the actual issue in that case is it's 373/374, is very sort of simply stated, not so easily determined, which was whether the claimant who developed multiple sclerosis after a road traffic accident could establish, or the pursuer I should say, that the MS was caused or materially contributed to by the modest injury in the road traffic accident. So that's bottom of 373 over to 374. And the trial proceeded, and you get this if you go to 376 between B and C. The trial proceeded with a tremendous amount of detailed expert evidence, all of which was subject to cross-examination in the normal way. And you see how the Lord President indicates between B and C that unfortunately, nevertheless, the Lord Ordinary really makes no effort to analyse that evidence or to explain why he accepted some of it and rejected other parts, that being the function of the trial judge. You hear all of this conflicting evidence, all subject to cross-examination, and you seek to resolve issues, and if necessary, exceptionally, you can hold that a case is not established on the burden of proof. And exactly the same thing happened in the MBR Acres case that you were taken to this morning. That was a case with conflicting evidence and cross-examination. Fine, that's normal, or what I call a standard case. Furthermore, some play was made yesterday by reference to the Davey and Magistrates of Edinburgh case, to the fact that the Lord Ordinary in that case was indicating that it was appropriate to reject expert evidence, even though there was no conflicting expert evidence, only conflicting witness evidence of fact.
Well, that was hardly surprising, because a lot of people said our properties are damaged at this time, and the expert evidence that was that it couldn't happen. If you find that it did happen and the only cause of the damage was the defender's activity, then you reject the expert.
Absolutely, and that's why we've always been at pains to say uncontroverted expert evidence means evidence of which there is no A, contrary factual evidence, B, contrary expert evidence. That's why I've been at pains to go through that every time. And I should say, none of this was an issue before Mr. Justice Martin Spencer, and it's only been raised again orally for the first time today. It wasn't an issue in the Court of Appeal. And can you please go back to page 161 of the bundle? 161. We didn't put cases before the Supreme Court on this because it wasn't necessary to do so in our view, nor in the respondents. If you go back to 161, started at the end of paragraph 19. This is Mr. Justice Martin Spencer summarising the claimant respondent submissions, and at the end, here there was no other evidence against which to weigh the evidence of Professor Pennington. It should therefore have been accepted. Para 20, Mr. Weir pointed to other examples of factual evidence being preferred to that of an expert, and we referenced 2 English cases. We didn't reference the Davy case, but there were 2 English cases, Kingsley Development and Armstrong and First York Limited. Just 2 further examples. And then if you kindly go to page 163, paragraph 23, in the middle before the quote, this is summarising the submissions of the defendant, my learned friend, and you'll see where it says alternatively, the court may prefer factual evidence to that of an expert, as in Kingsley Developments and Brudenell. Thus far there was no disagreement between the parties, and so it's remained. So it was as if there was some blinding new point coming out of Davy. There wasn't. This was all common ground from the High Court. Now can I consider the position where the claimant adduces expert evidence and it's uncontroverted, so no contrary factual, see Davy, Kingsley, Armstrong, etc., no contrary expert, and no cross-examination. Now in that situation, the position is materially different. As my Lord Briggs observed, the overall role of the court is the same, namely to ensure a fair trial. But the route by which this is achieved is different. Because in such a case, the rule, which I call the rule in Brown and Dunn, and I entirely understand the observation by Lord Hodge that it may be apposite to give it a different name because Brown and Dunn is a case dealing with credibility in the sense of those are the facts of the case, and if this court is with the appellant that it's a wide application, then well, no doubt it will end up being called the rule in Griffiths and TUI. And that'll be that.
I mean, there's been repeated approval for what was said in the textbook Phipson.
There has, my lord.
And what is interesting is that the learned authors of that maintained that text in the latest edition and found it as their authority for it. The dissenting judgment of Lord Justice Bean.
Indeed, your lordship quite clearly took that point yesterday when I went to that, and quite clearly have the point that Phipson is expressed in general terms.
Yes. And has been approved repeatedly by the courts.
Repeatedly, I think I did all of them, but there's actually a chance I didn't even do all of them. I'm thinking possibly Lord Justice Latham and Deepak approved as well. I mean, there really is quite a list.
You're only halfway through, I think, your description of the judge's role where the evidence is uncontroversial.
Oh, absolutely.
Sorry.
Yes.
Yes.
Yes, my lord. We've got
critically.
Yes. Well, to get back to the case, my lord. Yes.
And you started by saying you must always assure a fair trial.
Yes, my lord. And the route by which it's achieved different because but I'm just going to keep calling it, if I may, the rule in Brown and Dunn, even if it's the last time it's called the rule in Brown and Dunn, before something becomes the rule in Griffiths and TUI. This will be the rule in Brown and Dunn final hurrah. And in such a case, the rule in Brown and Dunn is engaged when the respondent submitted orally that the role of the court cannot be affected by the absence of cross-examination. That's pretty much a quote. The role of the court, this was his submission, the role of my learned friends, I should say, sorry, the role of the court cannot be affected by the absence of cross-examination. That submission is simply to ignore or deny the existence of the rule in Brown and Dunn. Now, there will be cases where the court will consider that a failure to put a point to an expert has not led to unfairness of the trial, and Edwards and Life Science is a good example. But whereas in this case it's clear that the issue is central to the trial, there is a clearly expressed opinion that supports the claimant's case, and that evidence is entirely uncontroverted, not challenged at all by contrary evidence or by any cross-examination, then it is the case that the court needs to accept the expert opinion evidence, unless it's incredible, in order to ensure that there is a fair trial. And that cannot properly be described as a derogation of judicial function in favour of trial by expert. Rather, it is the trial judge giving effect to the decisions made by the parties as to the conduct of the litigation. Here, the respondent electing not to serve its microbiology evidence. For the avoidance of any doubt, my lords, the respondent obtained permission to have a microbiology report. One will only assume obtained a microbiology report, and in the event elected not to rely upon it. It's page 63, which is the chronology annexed to the SFI. So it's page 63, my lord, 63. And if you follow the dates down to about halfway down, my lord, 6th of September 2018, respondent states it will not be relying on evidence from a microbiologist. So it's like-for-like expert. It's simply, it had its report. I'm not asking the court to draw adverse inferences. I don't need to. We had our own and it was uncontroverted. I'm saying they had their own and they chose not to rely on it. That's the position. That's
it was the gastroenterologist's report that came too late.
Yes, it was.
Yes. So here the decision was that they must have concluded that their microbiology report didn't advance matters.
Not all just so.
It's tantalisingly uncertain whether that happened before or after Professor Appellant's report was served.
Well,
it mostly happened on the same day.
The same day.
I think, yes. I mean, normally what happens is solicitors send to each other and say, please don't open until you've sent me yours. Essentially.
Okay.
So you can actually achieve something that materially equates to simultaneous exchange.
Yes.
Rather than I'll have a peek at yours and decide whether to serve mine. That wouldn't be the most equitable system. It would lead to people waiting until sort of 4:29 if the date was serving by 4:30. So that's a decision, and it's also the trial judge actively deciding the case in accordance with the core principle of fairness. And we don't say at all, ever, that the defendant was obliged to serve its expert evidence, or that the defendant was obliged to cross-examine Professor Pennington. But we do say that the defendant has to live with the consequences of its decisions. And that's why I opened the case and set out at paragraph 7 how the civil justice adversarial system operates in this country, a key component of which is the judicial function is limited and controlled by decisions made by the parties. So this is normal. And I would ask this court to note also that the respondent seemed, at least to us, to be very close to agreeing all of this orally. Because when pressed on the issue of whether a failure to challenge a witness of fact by way of cross-examination engaged the rule in Brown and Dunn, the learned friend confirmed that in such a case, his words, the judge would be bound to accept the answer of the witness.
I did revisit the question.
I don't wish to exclude the court taking into account all of the submissions that the learned friend has made, but it is not unfair for me to highlight some of the submissions that the learned friend has made, but the court will have the full context of his submissions, of course. But it was the rapidity with which my learned friend accepted. It was, of course, in such a case, the judge be bound to accept the answer of the witness. This is because this is normal. There was no complaint there that this is the judge somehow derogating his or her role to a witness of fact. Such a submission sounds absurd, and yet it's turned into one just because it's an expert. It says, oh, you're derogating to an expert. But you're not derogating anything. You're performing your judicial function.
The quite detailed statement of what happened here in the schedule doesn't itself solve the problem which I put to Mr. Stevens about whether Miss Professor's attendance was dispensed with. He seemed to have been ill and recuperating at home.
My lord, yes.
But in a sense, the circumstances in which he didn't attend for cross-examination are rather left up in the air by this document.
Yes, I think he didn't attend because he wasn't asked to attend. is the right answer. I made a submission. I sort of feel like it was today, but it must have been yesterday. I made a submission. The normal way in which this works in the Master's Corridor and no doubt in the County Court is that you get an order. The order wasn't made in this case. Certainly in the Master's Corridor, in a bigger case, you will get that order standard in the case management.
What will the experts do attend for cross-examination?
To the extent that the experts remain in disagreement following production of joint statements or words to this effect, the parties will be at liberty to attend trial the parties' experts will be at liberty to attend trial to give evidence. Something very, very much to that effect, no doubt put more attractively in a pro forma document used in the Master's Corridor, but that's the standard order in higher value claims. That was not an order we've seen. We've seen the order in this case. There wasn't that order, and so the order that needed to be sought by the respondent was an application for permission to cross-examine Professor Pennington. And we've set out repeatedly in every stage, I think, of the appeal process that that's something they could have obtained. And at no stage, I made the submission yesterday, and I still haven't heard a submission against it. At no stage has the respondent said, if we'd applied, we wouldn't have got that order.
Yeah. So was Lord Justice being wrong in his statement that was being impugned?
He's talked about it being the default, and I think it rather turns on, an analysis that doesn't particularly take the court much further as to what's meant by default in that context. He's invited reference to Part 35. We've had a look at what Part 35 says. This is the accurate position that I've sought to set out just now.
So in practice, people seek an order from the court?
Normally you seek it at a CMC,
Yeah.
and you get it at the CMC. Because that's an efficient way of dealing with the business. If not,
What if not at the PTR?
if you have one, my lord, if you have one, because there's less
likely in a
other worlds of technology construction, etc. But in our world, in the Queen's Bench Division, they become rather sort of dispensed with.
Although one needs the order, the practice is that if it's requested, it's
yes.
granted.
I can't really speak to the county court practice, but certainly in the Master's Corridor, for instance, you can do things even by email and just ping an email effectively and say this is what we'd like to do. If it's something like that, there's a very high chance they'll do it in an efficient and helpful cost-saving manner with such an issue. And as I say, at no stage have I faced the contrary submission. No, that we wouldn't have got that. That couldn't have happened. At no stage. Can I now just look at the scope of the rule in Brown and Dunn? The respondent started with 4 categories of case in which Brown and Dunn was said to have applied by reference to case law post-dating Brown and Dunn, and I think the observation by Lord Briggs drew out that, of course, the right answer is the right answer whether a case has addressed the issue or not. And this court is looking at the fundamental issue, not as another court decided it at an earlier stage. Brown and Dunn seems to have been very quiet for a very long period, and more recently to have been applied with much greater degree of enthusiasm. And I think that is rather an echo of that which Lord Justice Jacobs set out in the Markham case when he said it's in an obscure law report and I'm going to have to take you to an Australian case to show you its existence, whereas now we're very familiar with it, not least through Chen and Ng. So it's maybe having something of a renaissance in terms of its reference in court, but that's neither here nor there. The issue is one of substance, not one of who's been where so far. There were 4 categories which then seemed to increase to 5, all of which seemed to be porous and in no way self-contained. But can I just, rather than look at those categories generally, can I look at category 4, which was the following? It was said to be where a party invites the court to accept a positive case that it advances that was not put to the other side's witness. And I think I understand exactly why this category 4 is being advanced, because it's an attempt to distinguish cases in which there hasn't been an attack on credibility and Brown and Dunn has been applied. But if we just have a consideration of category 4, if that's right, it would mean that the defendant must cross-examine the claimant's expert if the defendant has its own conflicting expert evidence, which is obviously its positive case, but need not cross-examine the claimant's expert if it elects to produce no expert evidence of its own, and by this route can sidestep the business of cross-examination in favour of relying on the burden of proof. In other words, the defendant is in a stronger position when it has no evidence of its own, which is A, wholly counterintuitive, and B, respectfully, cannot be right. The correct position is that where the claimant has expert evidence which is uncontroverted, and the claimant proves his case, and the defendant is taken to admit that evidence. So controverting it by its own expert evidence is at least a start for the defendant. Not controverting it at all, either by contrary expert evidence, contrary factual evidence, or cross-examination, requires the court to accept the claimant's expert evidence as a matter of fairness. And that's a submission I've already made.
So you say once that fourth category has been included, this case is our fortiori?
That's exactly the language which I would have employed had you left me to not give me the answer to the question, my lord. Yes, it's exactly the language. And for that reason, the claimant cannot hide behind distinguishing the cases I'm going to mention in a moment, which are Nagel and the life sciences case, on the basis that they involve positive contrary cases, which is why he says, oh, there are no cases dealing with just an attack on reliability. Nagel's an attack. I showed the court, that's the Lord Justice Leggett judgment, I showed the court that case. Yes, there's a positive contrary case, so what? It's not an attack on credibility, it's an attack on reliability. And Edwards Life Science is an expert evidence case, which is not an attack on the credibility of the expert. It's an attack on a challenge to the quality of the reasoning of the expert. And for that, I'll just give you the references if I may. If you look at paragraphs 59 to 60 in Edwards Life Science at page 471,
59 to 60.
59 to 60, and also have a look, please, at paragraph 70, brackets 2. You'll remember that Lord Justice Floyd has a sort of series of reasons as to why there wasn't unfairness in that case. That's page 474. And you'll get from that part of the judgment how it's just an attack. For conflicting expert evidence, not that has to say this expert has come to the court to lie or something exciting like that at all. Can I now turn to the full scope of what I've understood to be the respondent's concession? As I followed it from following a series of searching questions, which, as my Lord Stevens observed, may have started from Lord Stevens, but the baton was passed down the line at various stages. And following these searching questions, I understood the respondent to accept as follows. But as regards witness evidence of fact, essentially, although this of course was not stated in these terms, the rule in Brown and Dunn applies generally. Because certainly I noted that it was conceded that it applies where there's a challenge to the reliability of the witness's evidence. There was a discussion in relation to memory and an attractive term which I think was...
I think the concession was only that it was difficult to find a principled reason why it shouldn't apply also to memory. I'm not sure Mr. Stevens accepted that Brown and Dunn went that far.
Well, I think may not matter. I think part of that was a distinction between what he says is Brown and Dunn and what this court may describe as Phipson. In other words, that it's not Brown and Dunn per se. I've been calling it the rule in Brown and Dunn because I've got to call it something. But and perhaps cases shouldn't turn on concessions. But it's not so much that it's a concession. It's more the difficulty that my learned friend experienced in seeking to box the rule into credibility, which already slipped into professional misconduct, and then it shifts into positive contrary case, which I've sought to show simply doesn't wash, when actually there was certainly recognition that I think forgettability was the attractive expression employed by a member of the court.
I got it from a judge when he was using it about my client.
Well, as long as it's about your client, my lord. So that is a part of reliability. That not remembering, they're all parts of it. And once you're into one part of reliability, I mean, I'm sorry, but it's not even a slippery slope. It's just plain as a pikestaff. We're dealing with issues of reliability. You can't start saying I've got a rule relating to the fairness of the trial, but I'm going to say it applies in memory issues, but not inconsistent statement issues, and so on and so forth. And as my understanding is,
Mr. Weir, you need to watch your time.
Oh, I do apologise. And my understanding is that there are really only two bases upon which you can challenge a witness. One is reliability and the other is credibility. That's it. And that's why I say, therefore, the rule applies generally. And it was conceded that the rule would apply in relation to expert evidence, and we heard that again today. And not just to credibility challenges, but also to competency in his field, the expert's field. And I've made this submission already. That's exactly what we've got here. And I'll just invite the court to look at some of the language which has been employed in writing. If you go to page 94, so we're in the respondent's case at paragraph 9.5, so pretty much in the middle of page 94. In the present case, as the majority of the Court of Appeal recognised, the respondent didn't contend the defendant was wrong, let alone challenge his credibility. Rather, the submission was his evidence didn't prove what had to be proved because it was insufficient, was exiguous, incomplete, suffered from inconsistency, and was inadequately reasoned. Which are damning criticisms which seem, at least to us, to go to Professor Pennington's competency. So we don't agree at all with the submission that was made, but reversing it, our submission is an attack on the competency of the report is an attack on the competency of its author. It's a little bit like if you can imagine an academic having a jolly good go at one of your judgments. For the paucity of its reason, for the scantiness of its reason, you might feel that there's a little bit more to that than simply an attack on the individual report, and not least if we lined up a series of your judgments and had even more fun attacking them all in one go. You might become sensitive to that issue yourself. In any event, transferring from witness of fact to expert witness, it's hard to understand how a rule can apply when challenging the reliability of witness evidence of fact, but not when challenging the reliability of an expert's reasoning, which is essentially what's going on here. In relation to Wood and TUI, I just wanted, if I may, just to take you to the early part of paragraph 31 at page 166 of Mr. Justice Martin Spencer's judgment. So I'd read out the latter part of para 31, but Wood and TUI, this is a delayed response to the question of my Lord Hodge. Wood and TUI, it was common ground before Mr. Justice Martin Spencer's page 166, my Lord. Paragraph 31. At the beginning, in relation to evaluation of the judgments in Wood and TUI, it seems to me Mr. Stevens, Queen's Counsel, is right when he submitted Judge Truman was not elevating those judgments to some special test which has no basis in law and which she found the claimant had failed to satisfy. Rather, the test she was applying was no more than his dictum that the claimant's got the burden of proving his illness was caused by food eaten at the hotel. So there really was nothing in Wood and TUI. I attacked the judgment of Her Honour Judge Truman on the basis she seemed to elevate into a test. Mr. Justice Martin Spencer said she didn't, but nor is there anything in it. It was just burden of proof. So he can't hang his hat on Wood and TUI providing some special test for gastric illness cases or the like. I'm extremely grateful for those 5 minutes. I'm within my overall time limit, but outside my reply time, it's extremely grateful to my Lord for allowing me to take the next.
Mr. Stevens.
My Lord, I'm sorry, just very briefly 2 points. My Lord Briggs' question about correspondence.
Yes.
I understand on instructions that there was no correspondence directed to the question of whether he could or should attend to give oral evidence. My Lord, the only other point is my learned friends referred to a new authority in reply. I'm not going to address you on it, but it was Stevens and Cannon on resort to the burden of proof. My learned junior, Mr. Clegg, has reminded me that, somewhat contrary to what Mr. Weir said about it being the last word on it, or the authority on it, and the very bit he took you to, has been considered in 2 subsequent cases of the Court of Appeal. If I could just give you their names, and we will provide copies. I'm very sorry they weren't in the bundle. The first was Verlander and Devon Waste Management, 2007 EWCA Civ 835. And the second, Constandas and Lysandru, 2018 EWCA Civ 613, which was a judgment of a 2-judge court comprising Lord Justice Kitchin and Mrs. Justice Rose, as they both then were. My Lords, I'm sorry that those weren't in your bundle, but we'll provide them.
If they can be produced, that would be...
They will, my Lord, and I'm grateful.
We'd be grateful for. Thank you very much, Mr. Stevens. Well, the court is very grateful to counsel for their submissions, both written and oral, in this case, which obviously has no little significance in relation to the treatment of the evidence of expert witnesses. Court's also grateful to those behind counsel who have assisted in the preparation of this appeal. The court will take time to consider the outcome of this appeal. Thank you.